Welcome to tutorial key point video 7 for W200, the last of our ordinary tutorials. There is, of course, at the end of August, the revision seminar, and obviously that's going to be a full day, and as soon as you can get the final TMA off, you can get fully down to revision. But by now you need to be working on that revision. There were two topics that we dealt with mainly in the tutorial. The first was competition law, obviously of relevance to the TMA. Competition law looks horrendously complicated. The key to it is Articles 101 and 102, and when you look at those in the treatise, it does look very long, but actually the very simple concepts at the start of it. Competition law is a much wider subject than you'll be studying. We will just be looking at the competition law involving enterprises. Doesn't matter actually what size those enterprises are, but obviously there has to be a European dimension. Let's start with Article 101. 101 has three things that need to be proved. The first, that there is a business arrangement. Now this has been worded in such a way that it covers all types of businesses and all sorts of arrangements. So have a look at the wording of the Act. You'll see that it talks about organisations, again not defining it in terms of companies or a particular legal status, but it has to be some kind of enterprise, or an agreement between associations of companies. Very often trade associations is what we're talking about here, or it could be concerted practice. But these arrangements, whatever their nature and whatever the type of the business, can come within Article 101. As I say, it is worded that widely so that it encompasses a lot. Normally these will be separate businesses, although theoretically there's no reason why Article 101 can't be used against two subsidiaries of the same organisation. Then, secondly, it may affect trade. The Commission doesn't have to prove that it has, it just has to have the potential. And thirdly, the object or effect. So it can be a deliberate setting out to affect competition, or it can just have that potential effect. Smallest agreements will come under national competition law. So the second one, the may affect trade, needs a European aspect to it. And that is Article 101. The consequences are that if it falls under 101, it is prohibited, and as a result, if there's an agreement made between two parties, the contract itself may stand, but the offending agreement, the part of it which breaches competition law, that will just be struck down as no effect, but there can also be major fines. Some anti-competitive behaviour actually benefits the consumer, and you'll see in there that there are block exemptions where the Commission will say under certain circumstances such an agreement will be valid, but it has to keep to those restrictions. Article 102 is usually about the single organisation, where that single organisation firstly is in a dominant position, and secondly there is an abuse of that position. Now something that often happens, particularly under the pressure of exams, is that students concentrate on is there a dominant position and forget that it's also just as important that there has to be an abuse of that position. Merely being in a dominant position is not in itself a breach of Article 102. The reason that so much attention gets paid to a dominant position is that there are different ways of working out whether a company is in that dominant position. and you'll see in the manuals talk of the RPM, the relevant product market. So which products are actually competing with each other? And of course the United Brands case is important here, because the argument was that bananas wasn't the relevant product market, because if bananas became too expensive and it was uncompetitive, the consumer would quite easily change to other soft fruit. So the relevant product market, and secondly the relevant geographic market. In the early days, people talked just about percentages. Has it got over 50% of the market? But actually you can be in a dominant position with under 50%, and sometimes even with significantly under 50%. And so the emphasis has been on market power. Does the organisation find itself in a position where it is able, without cost, to ignore competitive influences? So that's what they're looking for. Then, having decided there is a dominant position, you'll consider the issue of whether there has been abuse. What you've got in both those articles are some classic examples of anti-competitive agreements. You don't need to memorize those, just be aware of what they are, but any question you're going to face in an exam is going to be testing those 3 requirements for Article 101, the 2 requirements for Article 102. We then spent some time looking forward to the exams, and I say this really needs to be your major focus now. And I talked about cracking the code, analysing a question, looking at what it's asking for, and you will find in your notes that the university has sent you some very useful advice on looking at the words in a question and what it means in terms of what is expected for you in the answer. So the issue for you to consider is, what exactly is the examiner telling me about what he wants? In a sense, answering a question like this is like doing a crossword. There are certain key terms which give you a clue as to what they're looking for. So get used to cracking that code, and remember that when you're looking at that question, you need to focus on what is relevant to the question set. A common problem is, particularly with problem type questions, is somebody writing a long answer explaining all they know about a subject, and only right at the end applying it. You need to focus your answer on what the examiner is specifically asking you for. So get that right, and as long as the knowledge is there, you will sail in the exam. Finally, the TMA, as I say, get that done as soon as possible. There can be no extensions except in the direst of circumstances. And I mean, essentially, we're talking about serious tragedy here. But you won't get an extension. But I'd urge you, get it in as soon as possible, and then concentrate fully on the revision. First question, freedom to provide services. Again, if you go through that part of the manual which focuses on that, you'll have all that you need. And then question 2 is an Article 102 question. Well, thank you for that. This will be the last tutorial key points video. I will put something up about revision at the end of the month. But until the next tutorial, thank you.